Greetings and salutations. Welcome to another episode of the podcast Legal Beagles. And today we have Benny Blanchard from Florida. We're going to be talking about property taxes today. Property taxes and ordinances and how they apply or don't apply to the individual. And he's standing by and we're about to bring him in. So without further ado, here's Benny. How you doing, Benny? What's happening?
Hi, how's it going? It's nice to meet everybody here today. I'm sitting down here in the nice, balmy, sunny Florida, enjoying all the weather you guys are jealous of.
Fair enough. Fair enough.
So, I'm here today to talk about my property tax lawsuit that has been filed in Tampa Middle District Federal Court. We filed it on February 6th. All the parties were served on February 12th, and they all had the opportunity to respond with their standard 12B1 or 12B6 motions to dismiss by this past Monday, which, if I remember correctly, was the 4th. So everybody has put all of their MTDs in, and we put in one of our responses along with um, currently trying to craft something to hold on to the property appraiser for not doing their job. Now, they are quoting, like Alphonsus said on your previous video with him and Big Sip Brandon, that they're trying to use the Tax Injunction Act right now. And they are standing on it, they are screaming on it, and they're trying to say that, oh, these codes and statutes will apply to us. But the problem is, once you start reading the Constitution, it has some very interesting instructions for the property assessor. The assessor shall utilize all these factors. It must assess all these factors. So if he doesn't do that, the assessment is null and void. So I have up here on the screen right now three of some of the most important cases that have come out of Florida, in my opinion, because it really pinpoints the negligence of the assessor and his duties. So here's how the system works in Florida. The assessor is supposed to receive a copy of the income return that is filed with the Department of Revenue. Now, the problem is in Florida, nobody who is a citizen is required to file an individual return. So when you go to apply for a homestead exemption and they want your social security number, what they don't tell most people is they're using it to access an intangible return on the Florida website. And that is where he gets the income from. Now, the deceit is in the fact that they always do mass appraisals. And a mass appraisal has no assessment information other than this is what we valued all the land here in Florida at, because it's within our taxable cities. So the assessor doesn't want to do anything. He's going to say, you need to go to the Value Adjustment Board. Now, that's the purpose of citing the Tax Injunction Act. The problem with the Value Adjustment Board is they again, like Alphonse said, are looking at the income. They're looking at all of these factors, but they're not considering the income. So I went to the Department of Revenue's website for Florida, and it has on it the 2023 training manual for the Value Adjustment Board, which is where I acquired all of this fantastic information to shut them down. So I have three cases up here. The first one says, failure to consider one of the more factors set forth in this section 193.011 is sufficient to invalidate an appraisal done by the tax assessor, even when it is entitled to the presumption of correctness. That is McInfuss versus Miller, 421 South 2nd, 170, citing Strawn, 354, Exchange Realty Court, 272. The second notable case law that I want to cite is the 2009 legislation requires the court to determine whether the appraiser used an appropriate methodology in making the assessment. To allow the court to make this determination, the property appraiser must present sufficient evidence that describes the appraisal methodology and explains how and why it was applied in valuing the subject property. Under Section 194.0 301, Section 1, the appraiser has the burden of going forward and presenting testimonial and documentary evidence explaining how the appraiser satisfied each of that just valuation criteria. So if he has no income to consider, no matter what, the assessment is null and void. So why do I have to go see the adjustment board if I can tell this to him to his face? And this is what creates this whole deception. Now, the last court decision I want to enunciate is, under the decisions of a court, a tax assessor must consider each factor enumerated in the statute, although he may assign each factor such weight as he deems proper. Failure to consider any element listed necessitates the setting aside of its evaluation. So right there's three significant pieces of case law that null and void everything that you see with this tax assessment, but it falls on deafer ears than mine.
Yeah, let me take a moment to tell the audience that Benny needs closed captioning to hear me. So he's got a device that kind of serves the purpose, but if I remain silent, this is what's going on here. But he's doing a fine job. Continue on, sir.
It works. Whatever you have to do just so we can educate and teach people on this vital material.
Right.
Do you have any questions about this?
I know this well, but you might want to talk about a minute about homestead exemption and how that was meant for businesses.
Let me see if I can find material for that. That exemption. Here we go. We'll play some games here.
You can expand it a little bit.
All right. Now, just let me double check one more piece of information here. Invitations to the 16th Amendment. Oh, that was just the one we did. It's this one. Oh, I didn't download something I was supposed to. Here's the other one that I need. Okay, we're going to keep that in mind and put that over here behind it.
It's a little off the script. We're good. There you go.
All right. Let me scratch this one for now. Okay, here we go. All right. Now, let's talk about the homestead exemption. Here's my problem with the whole darn thing. I'm a real estate agent. So I have a concise understanding of what the four designations of property mean: residential, agricultural, commercial, and industrial. The only time these come into play is when actually, most importantly, when a legal entity owns the property or a legal entity tries to use the property. Now, that's where we have all this licensing and all this fun stuff come in.
And
they'll say,
what do you mean by legal entity?
A legal entity would be, by the terms of statutory construction, in this case, a taxpayer or other legal entity. So when you hear that, other legal entity refers to something that is statutorily known as person, which you will read individual, child, trust, LLC, association, or other possible combinations. When you use the rules of statutory construction, individual, when grouped with those other words, means a business. So that is one of the most important things to know, because if you are not a business, i.e. the or legal entity that goes next to taxpayer, you're not who they are referring to in the statutes.
Right. So someone in commerce, right?
I don't like to use that term
Okay.
because so many people throw mixed connotations at it. So my preference is simply to enunciate taxpayers and non-taxpayers. A non-taxpayer would be a citizen with rights to own property. A taxpayer is a privileged entity with the ability to hold said property, which is more commonly known as real estate, which is used to generate income.
Perfect.
So that's grasping all of that information is vitally important because it gives us the ability to start looking at how statutory construction works when you read a constitution, a statute, a rule, and even a policy. These have specific legal meanings that we do not use in common ordinary English language, or argot as I like to call it, or common if you're a Dungeons and Dragons player. So let's look at the first one here, which is the Florida Constitution, Article 7, Section 3, taxes, exemptions. And I've outlined this in bold here. There shall be exempt, and shall means must, be exempt from taxation, comma, cumulatively, comma, to every head of a family residing in the state, comma. Now, that is very, very important because this means you can take each one individually out and read the entire rest of the sentence. Now, not less than $1,000 into every widow or widower or person who is blind, totally, and permanently disabled, property to the value fixed by law, not less than $500. So basically, this is saying right from the get go, we're all exempt from taxation if you're a head of household. So now we're going to go read the statutes that accompany it here in Florida.
No, I don't
Florida
think every
Statute 196.031. Go for it.
I don't think everyone thought they were going to get an English language today with commas, but I like it.
I had a golden apple teacher, and she'd roll over in her grave and beat me as a non if I did not use it now. So let's go back to some of our important reading here.
Yes.
As I was saying, Florida Statute 196.031, exemption of homesteads. Unless the homestead property is totally exempt from ad valorem taxation, comma. That's the very first line in the whole damn sentence, which means it has to be exempt from the get-go. To continue, the exemptions provided in paragraphs 1A and B shall be applied before other homestead exemptions, which shall then be applied in the order that results in the lowest taxable value. A homestead exemption is something you apply to residential, agricultural, industrial, or commercial, but you own a homestead property that is exempt from all taxation. Now again, let's tie in all those concepts. We can build it brick by brick because once we have this foundation, it's much harder to kick us down. So now we have also in Florida Statute 196.181, exemption of household goods and personal effects. There shall be exempt from taxation to every person residing and making his or her permanent home in this state, household goods and personal effects, with a nice frigging period at the end of it. That means we are exempt from taxation if you see his or her. It's talking about the citizens.
So, Benny, is there similar statute in every state?
Yes, absolutely. The big thing is they like to use fancy jargon based on each state because each state gets to create its own terms and laws and statutory construction. Well, to a certain extent, let me take that back, but they still have to follow the rules, but how they want to construct something can very easily mistake folks.
Right.
So again here, if you see his or her, it's talking about the citizens, Article 1, Section 2 in here in Florida. Yeah, let's go to our next image that's important with this. All right. Do. Now we're going to go to Florida Administrative Code. Administrative Code are rules. Rules tell the officials how they are to enact the statutes. So to give you an example, the Constitution and the state of Florida says that a medical marijuana form, the first signature is mandatory for children, but the statute says that the form is voluntary, but the rule says the form is mandatory. So right here we have a severe conflict of the statute, how the rule is following the statute and following the construction of the Constitution. I happen to be involved in an administrative challenge over this medical marijuana form because I understand how these rules act so well. So let's go back to it. Florida Administrative Code 12D 7.002, exemption of household goods and personal effects. Only household goods and personal effects of the taxpayer which are actually employed in the use of serving the creature comforts of the owner and not held for commercial purposes are entitled to the exemption provided in 196.181, which mentioned the his or her a few seconds ago. Creature comforts are things which give bodily comfort such as food, clothing, and shelter. That's liberty. Liberty is the right to be able to exist, to be able to use things, to just go and do stuff without being told, well, you need our permission to go get a bar of soap. No, I'm not going to play this game. Commercial purposes.
Most
Go for
people
it.
do not realize that their groceries are not taxed. Well, in Louisiana, it's not. I'm pretty sure that's pretty much
Yeah, so in
nationwide.
general,
But
all food goods are not taxable.
right, but no one realizes they don't pay tax at the grocery store, which is go look at your receipts and see. Now, liquor and cigarettes and all that you get the same place,
Or
yes, but
another
food
example
items
is
you should not pay.
services.
Right, and services, right.
So say somebody is a licensed esthetician and she's applying and using the materials on the person. There's no taxation in Florida for providing those services because you have the right to your labor. It's your private property. It's constitutionally protected via the slaughterhouse cases.
Now, everybody doesn't understand that.
And I get that completely, but we all have to hear it somewhere.
Right. So what you're saying, just so we know, in this country, property is sacred, and wages
Yes,
are your property.
all
So,
property.
so it begs the question: how does the IRS get interest in your property?
The
And
IRS doesn't have an interest in your property unless you voluntarily pay taxes and tell them that they have an interest in it.
right, right.
And yes, I don't have the Code of Federal Regulations in front of me, but it does indeed say
Yeah,
that
we don't have
taxes
to
are
get into that
voluntary.
today.
Let's get
But
back onto our
yeah,
subject here.
I just wanted to make the point, drop a hint that that's
Mm,
what's coming down
absolutely,
the way on
absolutely.
one of these podcasts.
What is so? The next section is keep going. Okay. Our next section is Florida Administrative Code 12D 8.001. All property to be assessed. Now, they harp on the fact that all property in the state is to be assessed, but there's rules to being assessed. You can't just say, "Hey, we're going to do that." Any 5-year-old knows that in a playground. Hey, that's mine. You stole it. Why does the tax man and the assessor get to do it? So let's take a look at this. Household goods and personal effects of every person residing and making his or her permanent home in this state are exempt from taxation. Period. Again, enunciation of somebody residing and making his or her citizen's home is exempt from taxation. No ifs, and, or buts. This is how the civil rights deprivation begins. Now, the most important thing to me in my case is, as a real estate agent, we all talk about warranty deeds, but why do we have title insurance? Why do we have title searches? So now, quoting again 12D 8.001, title to such household goods and personal effects may be held individually by the entireties, jointly, or in common with others. For those who are unsure of what in common means, that would be like, I'm not married, but we live together. We do all of this together. We're common law contracting to protect our own rights and use our private property, not in a business. Storage in a warehouse or other place of safekeeping in and of itself does not alter the status of such property. Personal effects is a category of personal property which includes such items as clothing, jewelry, tools, and hobby equipment. Now, here is the most important line out of this whole thing of all property to be accessed. No return of such property or claim for exemption need be filed by an eligible owner, and no entries need be shown on the assessment roll.
So
So we have a starting point.
what Benny is saying here is that in order for your property to be taxed, you have to file a return. Now,
Correct.
I don't know about any of you, but I have never filed a return on my house. I don't think any of you have either. So there's something amiss here. And I think
It got
Benny's
rolled
about
into those IRS state taxes over time, and that's again where another point of fraud began, because most people are afraid of the color of law. Oh my God, the authority figures are going to do everything. No, 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 no. We're bigger than them. We can smack them down. They're the servants of the people.
That's right. That's right.
Now, I'm going to take the next things I want to show you here and bring up the taxman's liability. Oh, the taxman, Mr. Taxman, we're coming for you. Okay, we got our next thing here. Again, we're all talking about Florida statutes. Now, Florida has a trick here. They like to send you to the Senate page to read about statutes, which is often incorrect, instead of sending you to the actual Florida statute page. So make sure it looks like something like this, folks. So, Title XIV 14, Chapter 197 is about tax collection, sales, and liens. 197.12, erroneous returns and notification of property appraiser. If a tax collector has reason to believe that a taxpayer has filed an erroneous or incomplete statement of his or her personal property, again, his or her, or has not disclosed all of his or her property subject to taxation, the collector must notify the property appraiser of the erroneous or incomplete statement. Incomplete statement. Now, erroneous means not according to law when you read through a few various law dictionaries. So he's got a job to tell the assessor, oh, no. So when he doesn't do this, he now implicates the entire RICO scheme because we have two parties now. Now that's the big thing here. With those two parties, we can get involved in 42 USC, 1982, 1983, 1984, and 1985. Possibly. We all have discussions about that wonderful thing.
Sure.
So the next word I want to talk about here, oh wait, I just did that. Here we go. Correction of erroneous assessments from Florida Statute 197131. Any tax collector who discovers an erroneous assessment shall notify the property appraiser. If there ever constitutes a double assessment, the tax collector shall collect only the tax justly due. He's got a duty to report this. That's how they get the counties in trouble. They have no law that tells them we can just tax it. You have to go talk to this person. You got a job to go and do this duty. Let's do our final one here. Oh, wait, we did that. So what's this one? uncollectible personal property taxes. Now, this one is more into play when it comes to tangible personal property versus real property. Tangible personal property is articles that can be sold. So, for a car lot, which is a commercial enterprise, the owner would not have everything owned as real estate. He would file a Form DR 405 along with the income return to show the Department of Revenue and the assessor what his collection of tangible property is for sale. So that must also be put on the rolls as something entirely separate. So just remember, folks, an ad valorem tax is a tax on the income from production with the property. A tangible personal property tax is a tax on something you're holding for sale with a sales tax, and they're keeping you accountable that way. So those are the big two definitions.
Now, is that rooster crowing? Is it morning over there?
I have several roosters. Yes, I got about 70 chickens on the property. So yes, we have some fun entertainment and background. I literally am homesteading.
Good. All right.
So again, why are you charging me to farm and live?
Good question. I think you've answered
So
that.
let's go to this, and then I'm going to answer that question for you
All right.
with my real estate knowledge. So, a tax collector who determines that a tangible personal property account is uncollectible may issue a certificate of correction for the current tax roll and any prior tax rolls. The tax collector shall notify the property appraiser that the account is invalid and the assessment may not be certified for a future tax roll. Again, they're saying in legalese it's got to be taken off. It can't be put back on until there's a true assessment done again. An uncollectible account includes, but is not limited to, an account on property that was originally assessed but cannot be found to seize and sell for the payment of taxes. Oh, wait, that's what we're not supposed to have done. And includes other personal property if the owner is identified pursuant to 197.4138 and 9. Again, it's not supposed to be taxed.
That's right.
Oh, we were talking about how the homestead exemption came into play. Back in the early 1900s, when they first started doing agricultural taxation, a farmer would often go to a bank for a loan. That loan would be used to buy said property for the intent of farming to sell to the public. Vastly different from what I'm trying to do today. The next thing that happens is the assessor comes by and he applies the homestead exemption. So at the very least, the man won't lose his home for farming with the rest of his fields. That is where homestead exemption really truly originated from. And over time, courts ruled that there wasn't any reason not to apply the same homestead exemption to one property, which is the residence of the business and its domicile.
My, how we have come a long way.
Yes. So it's lack of knowledge since the change of the school systems, because the schools are not teaching the primary language of America, which is our legalese. Again, we go back to we speak common argot.
What do you mean by that for anyone that doesn't understand what you meant?
America is a mixing pot. We've all heard that term before, but what we forget is that people use verbiage in ordinary language that might apply to trades, that might apply to legal language, banking terms. We're adaptable. We like to steal something. We call it slang.
Sure.
And as a result, that slang creates the common argot and everyday usage of the language. So to have a true standard of language so that all understand law, we have those rules of statutory construction, which is becoming a forgotten language as bad as Crete.
By design.
That's a, no, we're going to change that. That is the whole purpose of this podcast, is to begin to change that and begin the education of America again.
I say continue.
So, let's see if there's anything else I want to pop into here. Oh, I should have started this at the very beginning, but for everybody who wants to follow my case here, we filed in the United States District Court, Middle District of Tampa, case number 824 CV-00352 WFJ CPT. The last two are the judges that we have. One is the federal judge and one is the magistrate. So if you want to go to it and look over the pleading and look at how I've written this up to tackle Florida and start learning everything that we want to talk about for Florida, go find this case.
And you can also come to the Big Sip chat in Telegram and get help. And you got all kinds of documents and all kinds of case law and all the things that we've compiled together is all there. So at the if you Telegram app, the Big Sib chat. And
I cannot. I will say this. I started doing this 2 years ago because code enforcement tried to tell me, mow my frigging lawn. Guess what? I won. And after that, I have been nonstop.
We just had Tate on talking about this. So tell us how you beat him.
Yes, yeah. So code enforcement still rammed us through all their administrative procedures. But I found out that the person that they asked for advice was an advisor at the agricultural station in the county. She had no authority to tell code what to do, which is what she did. And that created the problem for them. That created the civil rights deprivation because they went outside of their boundaries and their authority to do such a thing, which renders their instructions as forbidden fruit. It cannot be used in the administrative court or anything like that. So they were forced to try to say, yeah, guess what? We're going to just take this away, and tried to sweep me under the rug. But once you piss me off, I'm keeping my eye on you.
So can you tell us the difference between an administrative court and a court where the U.S. Constitution matters?
Sure, administrative courts only apply to taxpayers and people who hold licenses. So let's take a look at the most common license everybody has, a driver's license. It's a professional license. It just happens to be regulated by the state instead of the cities and municipalities. So because that's done, they've created a separation where nobody can really go, oh, this is an occupation, because you're not picking up the occupational license from the local tax collector. Now, with that driver's license, you're able to go to an airport and rent a car or a motor vehicle from a company whose business is using the highways to conduct privileges to earn income. That is when it falls under the statute of state doctrine. In order to regulate it is where we have all of our 1920s, 30s, and 40s case law before everything sort of disappeared into the administrative courts today. Those administrative courts, because they're meant for those license holders, don't really have any authority. They still have to truly do due process, which means there has to be a a prosecuting instrument filed by the state attorney in order to really prosecute you for something in court. But because you hold a license, they attempt to shove it all into, you must use this license all the time. You're under its sphere of influence all the time. No, I'm not. If I'm not driving Benny Cracks Plumbing Services, that's when I need a license. If I'm driving my personal car going from point A to point B using the right to locomotion and liberty, what do you mean you're going to tax that? And that's what they've done. Then you fall into the second trap. You've registered your car and told them that you're using it in commerce. But the double side of this trap is all cops think you're supposed to have a registration plate, and so they bust you under the statute, and people don't understand they have the ability to say, but the car's not registered in a privilege. Please take this out of the administrative court. Have a nice day. The cops are very interested in throwing you in jail and funding the prison systems.
It's a fact. It's a lot like the homestead exemption.
Yes. Yes, it's the same thing now. So we're going to substitute it. The property assessment as a license to use the business and a privilege. It's just not called as such because we don't recognize the word real estate refers to that. Property used to generate income. Again, this is all my opinion, everything I've read. Other professionals, or not professionals, but equal parties involved in things like this have their own ideas, background. It's welcome. We need it. We must have this discourse to learn.
Yeah, real estate is a commercial term, right? What do you call property?
Taxpayer.
Right. What do you call property that's privately owned? And not real estate, but
Sorry, Alphonse, I know you're going to yell at me, but the old song about land patents has an eighth of a truth in there somewhere, because we started with this ability to convey land from man to man without needing the state involved. Now we have this warranty deed which describes everything as a freehold. So when my partner conveyed the property to me, we wrote up a private contract which was witnessed by another person. We stated what was conveyed to me, that I own the property. We have all these property rights. Now, in the laws of real estate by Boyer, there's many examples of different types of ways to convey, utilize, and whatnot real estate instead of what we think of as today's statutory means. This has to change again through all of the education that we can receive.
no doubt. No doubt. Anything else you want to cover?
Um,
You were
Study.
quick and efficient.
Mhm.
You were quick and efficient.
Quick and efficient with what?
The whole presentation.
No, thank you, thank you. I've been fortunate. I was toastmastered, so I got rid of most of the ums and distractions, if you will. But as long as I can present the thoughts clearly to everybody, and I'm teaching it, there's comprehension in the subject.
Yeah. Is that back to your English teacher that used to beat you for the commas?
No, unfortunately, because I couldn't listen to classes when teachers were standing up and talking, I just read everything. Teachers would leave me alone if I was reading a book. Not a cheesy whatever book, but okay, you're reading this. I can't fault you. You're staying busy.
Fair enough. Is there any other topics you want to cover before we go?
No, I think at this point, this is a fantastic start. We've got a lot of information in just this amount of time and window and a lot of different directions. So let's stick with that.
Okay.
And audience out there, please reach out to us. Demand some more from me if you need it.
Right. Well, let me give you the last word. You can close it out.
Close it out. I want to make sure everybody feels blessed. You are blessed to be here. God has given us this ability to experience this whole thing, but He's also given us the opportunity to protect our rights. And this has been enshrined in our Constitution by our founding fathers. Court case after court case says you must stand up for your rights or you will have none. So the solution to this is simple. Start studying. As much as we love to listen to music or watch a movie or something every day, choose to study law. Choose to educate yourself. And maybe someday you'll do what they did back in the Greek days. Leave trees that for old men will not sit in the shade of.
Thank you, Benny.
You're
I
very welcome.
appreciate you coming on and spending your time with us.
Thank you. Thank you again. I appreciate the appearance.